Okay, so last class you learned about industrial design and its basic components. So now why not to learn about the procedural aspect of registration and further on the criteria required for registration. As I mentioned that India per se there is no unregistered design right. So definitely you have to you will be owners of industrial design rights by virtue of registration, and definitely for registration always you have to meet some procedural, you have to go through some procedural aspects. Okay, so procedural aspect part we will discuss. Before that, just like say the always lies that when our intellectual property the different forms we discussed, that always we required to fix some criteria for registration of any kinds of intellectual properties, just like patents we already discussed. Copyright also we discussed that originality is the criteria, specifically patent novelty, inventive stage are the criteria. Similarly, they have the statute have created the criteria that your design should meet, then only it will qualify to be registrable. Okay. So what criteria they have specified, let's say analyzed those things before going to the procedural aspects. Okay. So now they mention a design which is not registrable. They have casted in a different way. The design which is not registrable means a design which is not new or original. If design is not new or original or has been disclosed to the public anywhere in India or any other country by publication in tangible form or by use in any other way prior to filing date or or where applicable the priority date of the application for registration. Okay. So first let's say read clause A. A design. So now if you cast that in a positive way, so to register in industrial design it should be new or original. So what type of design is not registrable? Which is not new or original. So okay. So now so for now we are assuming to register in industrial design, the design should be new or original. Okay. So new or original. So now if I asked, new means already you came across the word new when I discussed about the invention and novelty. You have come across the word original when we discussed about the copyright. Okay. So what is original? Original you will answer definitely independent creation or originated from the authors. What is novel? Means which is not available or no prior art. So here they created the criteria new or original, but statutory interpretation suggested that it should be new and original. So or they are interpreting as and. Okay. Now I will explain that part. Okay. So let's see, give the example. Already I have given the, let's say somebody have created a school bag in the form of Royal Bengal tigers. Okay. Just like say he created patterns like a Royal Bengal tigers in the bag, school bag. So if I ask that the Royal Bengal pattern is new, you will definitely answer with reference to Royal Bengal tiger which is available. So okay, in reference to Royal Bengal tiger, the Royal Bengal tiger pattern is not new in the bag. If I asked whether it is original, definitely you will give the answer yes, it is original, because it is originated from the authors, that who got the idea, means for applying the Royal Bengal tigers pattern in the bag itself. Okay. So definitely it is original, but the criteria they suggested new and original. So means the will explains taking a conjunctive that is and part. So the school bag now, if you ask that whether the Royal Bengal's patterns of the school bag is new and original. So, then now the new domains should be restricted with reference to the school bag or those kinds of article. If the Royal Bengal pattern is not available in the school bag or that class of article, then it is new in reference to the school bag, and definitely it is original. I referred already, it is originated from the authors. He has got the idea to give the patterns of say Royal Bengal tigers in the school bag. So, if in the school bag form the Royal Bengal pattern is new and original, or then definitely it will qualify to be registrable under the industrial design rights. Can I give one example more? Take the example, let us say Taj Mahal. Okay. So, Taj Mahal, no problem. Now, another person somehow converted into the Taj Mahal in the form of a paperweight, and is telling that Taj Mahal paperweight. Another person converted Taj Mahal in the table lamp and telling table lamp in the form of a Taj Mahal. So, all in the form of a table lamp it is new, in the form of a paperweight also it will be new, a different class of particles and new and original. So, in the form of a table lamp Taj Mahal new, in the form of a paperweight Taj Mahal also new and originals, and definitely it will qualify to be registrable under the industrial design rights. So, I think you got an idea about the new or originals or new and original. So, new originals by applications, new in that form, in that class of article. Original means originated from author, originals means application, original means application. By applications means the Qutub Minar shape or Taj Mahal shape is not unknown, but by virtue of application it in the class of article it is become new and original. Original by means of application, originated from the authors itself. So, the person definitely the person who got who will create that thing first in the form of a Taj Mahal shape pattern in a school bag, or then he will be should get the rights. Okay. So, has new not is not so should be new and original. So, has not or has been disclosed to the public anywhere in India or any other country by publication in tangible forms. Okay. Now, the school bag in the form of a Royal Bengal tigers, if it is available in public in India or any other country, then your design will not be considered a novel design. So, you have to be cautious regarding that. When I discussed about the patent, you have to do a thorough novelty search, just like say based on prior art search. You remember regarding the patents, prior art search based on keyword I referred. Similarly, here also the design database is available for search. So, you have to search whether the design is available in a public domain by means of publications in a tangible form, or by use means or whether somebody is using that design in anywhere by anywhere in the world. Okay. So, then you may ask me how you know that difficult task, definitely, but for that reason you have to use the different databases. Paid databases are available also. The non-unpaid databases like a public public databases in the form of patent office site databases. The USPTO you can in the site industrial design patent from India ipindia.nic.in you may search design. Okay. Okay. So, similarly sometime so other patent office databases may be available for search. You may tell me that this is only for registered design or patented design. What happened to the others form? When I discussed about the patent, I told you that patent literature, non-patent literature. So, there is the questions. Okay. So, maybe the databases may not able to cover all published documents. Okay. So, that the other part. So, this is the part contrary to contrary by publication in tangible form. This is to remember the tangible form or any other way prior to filing date, means if you file today, before that it is available in the publication form or publication in the tangible forms or by use, then your design will not be registrable. Okay. And the priority date, I referred, when I refer in a patent, we refer a conventional applications, just like say if you file a patent application in India and taking this is a priority, you can reach to other country if you file within the other country within a years by virtue of your Indian patent applications, that the patent application in Japan will Japan is a priority in a conventional country. So if you follow the conventional route, considering that your patent novelty will not be destroyed because of prior claiming in India. Okay. So considering that, similarly this is also applicable for industrial design. So it is the priority date priority have been fixed for 6 months. So just like that, if somebody file a design patent design application in Japan, and within 6 months if he files a design application in India, so by virtue of his design application in Japan, that Indian design application will not be considered not novel because of the Japanese patent Japanese design applications. Okay. Okay. So this is the A and B, the 2 points and its significance. I think you got some idea regarding that. And the clause C is suggested is not significantly distinguishable from known designs or combination of designs. Okay, just like say when we discussed about that, just like a patents, just like and in utility model part, the difference you understood that patents and utility model part. The inventive step requirement is high, threshold of inventive requirement is high in respect to patent. Threshold for inventive step requirement is less in respect of utility model. So similarly, kinds of criteria they try to put it out to somehow to block. Let's say somebody have created a design pattern of Royal Bengal tiger shape. Later on, he simply changed some of the pattern's position and claiming that to be novel to prevent that kinds of things. So they have created a criteria called it's not significantly distinguishable from known design or combination of known design. So like this way, somebody changed the position of the button in a code and claiming that okay, my changing the bottom position of the code is changing, giving some different look. So in that case, we have to look, have to generalize these characteristics. Okay, so it's not significantly mere trade variant or should be significant. So significant, not significantly distinct. Significant part should be analyzed. So just like bottom position change is not significant change. So may not be with reference to earlier bottom position. So may not be qualified to be for industrial design registration. Okay, so so industrial design registration, the criteria up to the point C you understood. Then comprise or contains scandalous or obscene matters shall not be registered. So considering the public morality grounds, they have created this criteria like something is obscene. Okay, and just like understood that for scandalous, that type of elements you are putting in the form of a shape and configuration of an article or in the form of a pattern and ornamentation of an article, that will not be considered to be registrable. Okay, so now criteria for industrial design registration you understood. With example, you may consider that how this chair wherever I am sitting, or that this PC or computers or that LCD projectors, that all can be qualified to be an article, and how can you consider that article in the form of a new and originals and prior published, if it not prior published, and not significantly and should be significantly distinguishable from that this type of things, then it may qualify for industrial design registration. Okay, so so what criteria industrial design should meet you understood for being it to be registered. So now quickly we can proceed further. So who can apply for registration? So definitely you should know who should apply for registration. The proprietor of a new or original design. Proprietors means owners of the new, means owners means authors. If you created the authors created the design, then author is the owners. Although Act has not specifically mentioned that authors always have to apply for registration. So the proprietorship can go just like in an organization. If somebody is creating the design for the organization, the proprietorship goes to the organization based on employee-employer contract. So, proprietor of the new origin. So, proprietor will be the employers, although authors will be the creator, the person who is creating that design, but who will apply? The proprietor of a new and original design. So, now where author of the design for good consideration execute the work for some other person means the person who, for whom the design is so executed. Okay. So, just like say a good beautiful case is there, a lady have been given to stitch some clothes to a tailor, and he told given a blueprint of the stitch, how, what type of color, what way it will be stitched, everything he has been provided. So, now tailor if he stitched the cloth as per the direction of that lady, in that case lady will be the authors, the owners of that design. Okay. If now the authors with reference to some just like employer contract, where employee is creating those design for that employer because of good consideration, in that case employer will be the owners or proprietor. Where any person acquires the design or right to apply the design of an article either exclusively to of any other person or otherwise means respective by means of assignment and others. Okay. In other cases means of authors, the means the authors, and where the property or in or right to apply the design has devolved from the original proprietor upon any other person, include that other persons. Okay. Just like say the original author has dies by virtue of devolution of the title, the ownership is going to his say legal hires. Then legal hire has got the right of to apply for that. Similarly, in respect of company dissolution or devolution, that title may be may goes to some other persons. So, the other person may be the considered to be proprietor or owner. So, who can apply? If I ask, then a proprietor can apply. The author can be also proprietor, or author execute the design in a good consideration for other, then that person will be the proprietors. Okay. Now, a design can be registered for any or all classes, just like I can refer that. Okay, just like Royal Bengal Tiger say patterns in respect to school bag, you can apply that patterns in a chairs, chairs also chairs. So, in that case you have to register for that pattern in a chair in a separate class and school bag in a separate class. Okay. You can apply those pattern in a cup or containers also, so separate classes. So, you have to register for, not like that your design by virtue of registration in a school bag, your protection will be available for chair and bottle or container, not like that. So, you have to register for that thing for others also. Okay. So, this is the one part. Now, go for procedural aspects. Okay. So, what is required for filing industrial design applications? A form 1 with the request fee, that's like say now it has been increased to 4,000 for a legal entity, and individual it is for 1,000. So, if as an author an individual he file it is for 1,000, as an organization IIT Kharagpur or other let's take it TCS or other organization file, it is 4,000. So, in the application form you have to provide full name, nationality, address means which address for which address that communication from the office should be made, address of the organization address of the organization along with the address of service. For service means let us say it is filed through an attorney, attorney's address of service will be provided. Then 4 sets of representation sheet in durable A4 size paper should be pasted in appropriate pages. This is essential. Optional thing, if you are filing through power of attorney, you have to give a general power of attorney or power of attorney. Then priority document, if you are filing through conventional route, in that case priority document is also required. And I will show the what is the form 1. Specifically, you are requested to register accompanying class number. You refer just like for container is class 19, name of the article you are referring. Then it is simplified form. Full name, design is to be applied to the article. Then if you are claiming priority, then you referred that document. So, the simple part. Now, come to the procedural aspect. Very simple also, filing an application, then they will provide a number and date, Then the so from the your date, that will be the your from the date of your application, your rights will start. Then examination of applications, then communication of communication of objection. If this is not novel, it is not a design, it is already priorly published, or that is not say mere trivial, just like say all those kinds of objection they will communicate. Then compliance, non-compliance, if you don't comply with the objection of that, that will be raised from the office, then it will be abandoned. If you comply with the objections of the objection, then it will be accepted. Okay, accepted. Then so that you understood that now it will be notified in official gazette that this design has been accepted by the industrial design registries. Okay, so understood that. Okay, so then there is no opposition there, but now they will issue a certificate. But within that, after that, after the notification in the official gazette, one important procedure they have kept it, that is cancellation. So any person can further cancel the your design considering those of those elements, just like criteria for registration not novel, or say just like not novel or no new or originals, not an it is available prior published form or prior working form, prior use form, or it is obscene. It's okay. This is not an article, just like say on that ground, all those grounds can be applicable for cancellation of your designs. Okay. So if you got got a certificates also, anytime your design can be cancelled on that ground. We referred that grounds are referred in, if you read the Industrial Design Act, the section 19 has referred. So, okay, so procedural aspect very simple. Filing of applications, they provide a number and dating of application, examination of applications, communication of objection to whom? On that address of service. If no objection also you understood, it will be automatically accepted. Okay. So compliance of objection, they will again re-examine, not like that. If that they will examine, then they may accept it. Okay. If that you are not agreeing with the objection as raised by the office, then you can ask for a hearing. Okay. Then in that hearing they may be the waiver can be. So here that's a different part. Appeal to High Court, this will be different. Now say it can be applicable to IPAB also. So this is the you just change it, amend it. Okay, this is appeal based on that. So the hearing, if they are not accepting, you are aggrieved by the order of the controller from in the office. So you can appeal before IPAB. So this part you just changed it, change it. Okay, this change it. This has been recently changed. Okay, this can you can apply before IPAB, Intellectual Property Appellate Board, IPAB. Okay, appeal before IPAB, just change it. Okay, so so understood the procedural part. Now what procedure you have to adopt it. Okay, so now I'll show you that some specific representation. Okay, just like one important parameters here for preparation of representation sheet. Others nothing. Just like in patents, we have to prepare a specification explaining the details of your inventions, then claim, then prior art, all sorts of things. Here nothing is required. So understood. So simply you have to give the form 1. Form 1 is also very simple. So that name of the applicant or the class where you are registering, article name, and all sorts of things should be remains in that form 1. Then along with that you have to give a representation sheet, and three sets. I think 3 sets is required for that. Okay, so like this way. Here representation sheet includes a name of the applicant, this XYZ Private Limited Company, number of seats, how many seats you have, just 1 seat or 2 seats. This is seat number 1 maybe. So what you are giving, a front view of a chair, they are registering a chair maybe, a front perspective view of the chairs, that like a front perspective view, back view of the chairs, top view of the chairs, bottom view of the chairs, all sorts of views of the chair they are providing, and that they may give a novelty statement. That novelty resides, they refer like the novelty resides in shape configuration of the article as illustrated. Means like this way you have to prepare a novelty statement. Means okay, a novelty resides on the shape configuration ornamentation of ornamentation of the article illustrated, and you can give a disclaimer statement like this way, because in this chair lots of other features like mechanical feature or functional features are involved. Those will not come within the purview of industrial design. So you may create a say disclaimer statement by virtue of that no claim is made by virtue of this registration in respect of any mechanical or other action of any mechanism whatever, or in respect of any mode or principle of construction of that article. I already referred that functional features will not come within the purview of industrial design. So, you have to give a disclaimer statement. So, similarly, you can give a disclaimer statement, no claim is made if some trademark or logo is also coming within the features of an article here. So, you have to give a disclaimer and a statement regarding that also, just like no claim is made by virtue of this registration with reference to any trademark, letter, word, symbol, whatever is appearing on the figures. Okay, so, you understood how to prepare representation sheet of an article during registration. Okay, just like say prepared this way. So, what way? You give a font perspective view. So, you remember that engineering drawing is not allowed. You can give the drawing in the form of perspective views, perspective view, no problem. Sometimes dotted line is not allowed. You understood why? Because dotted line will not able to give you to assess the design features applied to that article. So, you should give better to give a perspective views, but you may ask me whether I have to give all perspective views, front, back, top, others. No, you may consider your design feature is restricted in the front perspective view. So, you should give the front perspective views only. Okay. But if you consider the design features is involved in all back perspectives or side perspective view also, then you can give the front side perspective view along with the front perspective views also. Okay. That way you have to decide. So, if you think about that, okay, I want to distinguish or pinpoint my novel features, then you may love that, okay, novelty reside on the as marked on that article, novelty reside on the point as marked on that article. That way also you can pinpoint the novel features on the articles. Okay. So, that's why how to prepare a representation sheet by means of giving a views, perspective views of article is the prudent way. You may give a photographs of the articles also. You may not require to give the physical specimens of the article, but if the controller asks for that, you may have to provide, because controller is not able to judge what is the article, what is the nature of the article, whether it is a paperweight or whether it is something else. In that case, they may ask to give a physical specimens of the article to access what is the article itself is. So, in that case, you may have to provide the article. Okay. So, now wind up this class specifically. So, now that okay, this is the dated and signature. So, now you understood what you understood. By virtue of that, you understood that what way you can register your industrial design. Okay, very simple. You should know the criteria for registration. You should know who can apply for registration, or whether you can apply through your attorney or say a patent agent. That can be also applicable. Then it's a very simplified way why to go through attorney route. You yourself can file your industrial design applications. Okay, application as a proprietor or owners. Only when there is a need for hearing and other cancellation part, you may hire some advocates or agent for that. Okay, so this is overall with reference to the industrial design filing its criteria, who can apply, what is the workflow in respect of industrial design, all those aspects. Okay, let's stop here for industrial design part. We will further continue with other attributes and comparison.